Hi there, it's Carolyn Elephant of MyShingle.com. So earlier today, I was on a webinar that was sponsored by Anthropic about Claude in the using Claude in the legal profession. Apparently 20,000 lawyers signed up for the webinar, and while I can't say that there were 20,000 people in the webinar room, it was pretty jam-packed and there were a lot of different questions. And one of the most common questions that came up was whether Claude can be used securely by attorneys if they're inputting client data. So there were a number of questions about security concerns, which Claude addressed, which the speakers addressed a little bit. However, I've done some extensive research on that, and I wanted to share the results of my research in this presentation. That's going to be the first part. And then what I did is I took my research and I created it and I converted it into a Claude skill. And that Claude skill will assess the confidentiality of any AI platform to determine whether it complies with lawyers' ethics obligations. And so that's going to be the second part, is showing you how I created the skill and how the skill functions. So if you're interested in ethics issues and confidentiality issues related to AI, or if you're interested in the nitty-gritty of how skills work, this presentation is for you. So with that, let's get started on the ethics issues. This is a paper that I wrote a couple of months ago about how attorneys can ethically use generative AI for client matters without having to redact everything. Now, we all know that if we're just making general inquiries on AI, just asking basic questions or fact patterns without identifiable information, that we can use AI for that without breaching any type of attorney-client privilege. And we also know that we can use the cloud to store confidential client information. Lawyers who use platforms like Clio or MyCase have been storing all types of privileged client information, from potentially credit cards to social security numbers, and there have never been any issues about whether that data is compromised just because it's in the cloud within the control of a third party. But using an AI platform tends to raise additional questions because the information that's being input is being run through these AI models, and that can raise some questions regarding security and whether the information is being kept sufficiently secure to avoid waiver of attorney-client privilege. So I looked at the bar opinions on use of AI for client matters. There's both ABA Formal Opinion 512, which is discussed in this paper, and also a number of State Bar Association opinions. From what I was able to glean, these opinions focus on 5 different factors. The first factor is whether there's sufficient data security. So that's talking about whether the data is encrypted. And if you're going to be putting confidential client information into an AI platform, you want to make sure that the information is being sufficiently encrypted, just as when you're using a practice management platform, you're going to look for data security too. And most AI platforms, I believe, do have sufficient SOC 2 compliance and data security to keep information protected. The next factor you want to look at is whether there's any training on the input. Training on the input is really a hard stop no. And the rationale there being that training on the input exposes your data to third parties, and that destroys any expectation of privacy. So if you're using an AI platform, if you're using an enterprise model or a business level model, typically training is turned off by default. If you're using a free or customer level model, you can turn training off yourself. But that's one of the features that you want to look at when you're evaluating a platform, is what degree of control you have over training. And then if training isn't turned off by default, you want to make sure you turn it off yourself. The next issue that comes up is this idea of memory cross-contamination. And this is really a factor that's discussed primarily in ABA Formal Opinion 512. A lot of the state bar opinions don't really address it, and honestly, I think it's kind of a red herring. But the ABA opinion, formal opinion, discusses, well, what happens if you have a situation where you're researching details of client 1, and then somebody else from the firm gets on the same system and researches issues related to client 2, and information from client 1, protected information, seeps over into the conversation. The ABA opinion flags that as a potential confidentiality breach. Now, personally, I disagree with that, because if the information is all in the firm, the obligation to keep it confidential still applies. But assuming that it is something that matters, you want to look to see if the platforms allow you to have control over memory. And many platforms do. They allow you features to turn memory on or off, or to do incognito searches so that you don't trigger any memory for that particular level of search. There was no expectation of privacy, and therefore. Now, the next factor you want to look at is whether a platform allows for human review. There are a couple of cases in the social media context where people used a social media platform which they believed to be private, but it turned out that there were content moderators who were reviewing the output to determine whether it complied with the platform standards. And courts had held that that destroyed any expectation of privacy and hence any protected status that that data may have had. So how does that relate to AI platforms? Well, with some of the free versions of Claude or ChatGPT, there is human review to determine whether the output is consistent with the platform standards. So for example, if you were using AI for pornographic matters or for domestic violence or some other type of intended violence, that content might be reviewed and flagged. If you're on a business or enterprise version, there typically isn't any human review except for some sort of engineering oversight to determine whether the platform is operating correctly. And again, that type of engineering oversight and troubleshooting, that level of review is very common with most cloud services too, and nobody has ever alleged that that level of review would somehow compromise or breach the attorney-client privilege. Data retention is an issue that comes up also. I guess the theory being that if a platform doesn't retain any data, then if there's litigation, there's no data that can be disclosed. And so your data is protected if it isn't retained. To me, that is kind of foolhardy. Westlaw and Lexis retain all types of data that you put in. They retain it for up to a year, and nobody has ever said that that's problematic. You want a research platform to retain data. Nevertheless, if you believe that a data retention policy is going to increase possible exposure or disclosure of your data, then there are AI platforms that allow you to have control over data retention. With most paid plans, data is retained for, I think, maybe 30 days. I'd have to look at the terms, but it also gives the user control over the extent of time to which the data is retained. And so you'd want to look for a platform that allows you to control that and to minimize it if you think it's going to cause risk. The last issue you want to look at is HIPAA compliance. Most law firms are not subject to HIPAA. I'm not here to say one way or another if your firm is going to be subject to HIPAA compliance or not, but if you are in fact subject to HIPAA, then you would want to avail yourself of an enterprise plan that has business associate agreements in place that would allow you to qualify for HIPAA protection. But again, if your firm isn't subject to HIPAA, that's not even an issue. You don't even need to go there. It just is irrelevant. So I leave it to you to determine whether you're subject to HIPAA or not. And I will include a link to this so that you can read through it yourself and use it as a reference guide. Or what you can do is you can follow along with the next section where I show you how I've turned it into a skill that you can also use to evaluate agreements with using it as a skill. So here we are back at Claude, and let me go into my customized toolbar. We're going to go into skills, and here we have the AI TOS analyzer. And what I did to create this as a skill was I uploaded that paper that I had prepared that I just shared with you. And I worked with Claude to put in some of the requirements that I wanted my analysis to include. And you can see here, we can look through the source material. And this is a description of the skill. It's to analyze any AI platform's terms of service, and it evaluates those 6 rubrics that I discussed in the paper. And it tells the platform when to use the skill. It analyzes the different rubrics, and then it gives it different ratings. I asked it to apply ratings, so it will give a rating as to whether it's going to pass or fail. It gives a detailed analysis, and it makes recommendations. So what I can do now, and so you can essentially do that with any paper you have. You can skillify almost anything. If there's a court ruling that comes out in your area that requires you to draft a contract in a certain way or include a clause in a certain way or litigate a case in a certain way, you can take that opinion and turn it into a skill. And so like I said, what I did was I took the paper that I drafted here and I skillified it. And so that means that I can have AI do the research consistent with the standards that I researched. So now let's go ahead and run the skill, and I'm just going to go into chat to run it. So now let's go into Claude chat and run the skill, and I'm going to ask Claude, apply the skill for analyzing the AI terms of service, apply the skill to analyze the AI terms of service for Claude Cowork, and produce a written report for me using that skill. And let's see what it does. Checking the skill, it's reading the file. Let's see what it comes up with. We'll hold off and let it run. Okay, and so it checked what the assumptions were. It says that Claude Cowork is a new product, so it doesn't necessarily have a terms of service for it, but it analyzes it under Claude's other terms of service. And because I asked it for a written report, it's building the document in Word. Now here it's relying on its knowledge as of January 2026. I probably should have asked it to go out on the web and get the most recent version of the terms of service, or maybe I should have just uploaded the most recent version, but let's just let it run and see what it comes up with. And so here's the report it prepared. First, it gives me this caveat about general risks attendant to agentic products. And remember, because Claude Cowork is a new product, it doesn't have its own terms of service, or maybe it never will have its own terms of service. And so it had to add these extra caveats, which I didn't ask for in the skill, but which are provided anyway. Here's the quick list of ratings that it put together. And you can see under the free and pro and max plan, there's partial controls, partial protections. It passes the confidentiality test under the team and enterprise version. And then it gives a detailed analysis under each of these rubrics. So data security, training on user input, and it goes through what each of the terms of service provide. So now let's see what it says about training. So it says that's the most consequential rubric for attorneys, and that was something that was reflected in the skills in the paper I wrote, talking about how that's really a very important factor. And it talks about here how under the free, pro, and max plan, you have the option of opting out of training. But it says that this is a settings-based protection, not a contractual prohibition. And as a result, it gets a partial rating for security because the safeguard depends on the user remembering to toggle the setting. So what that means is that yes, there are ways to safely use the free, pro, and max plan for if you're inputting client data, but it's not as secure as if you were to use the Teams or the enterprise version. And the report discusses that here again. The key finding for any attorney using Cowork with real client data, team or enterprise tier is the first meaningful threshold. The consumer tier opt-out is better than nothing, but it's not an ethics grade safeguard because the setting can be silently changed, whereas the contractual protections that you get with those other products can't be. Claude discusses the memory here. It rates all tiers partial. It acknowledges that memory and cross-contamination can be a hazard, which again, we discussed. I think it's a little bit of a red herring personally, but it says that the mitigation is to disable memory or scope projects per client, and that's available on every tier. So the reason it gets a partial rating is because it has to be controlled by the users. Now here's a discussion of the human review of content. Claude acknowledges that the free, the pro, and the max plan do allow for broader human review than just narrow incidence-based responses. And as a result of that, Claude gives it a rating of partial for security purposes. That's something that could warrant further research. As I've noted, there are cases that I mentioned in the report that I provided from the social media context where broader content review was held to destroy the expectation of privacy and hence the privilege. Those cases may have allowed far broader review than what's allowed under the free, pro, and max plan. So that may be something you want to take a closer look at if you're going to be using the free, pro, or max plan for client information. Data retention policy says that conversation data is retained for up to 30 days. But with the team and enterprise plan, you can set workspace retention policies, including shorter retention windows. And then it just discusses what's required for HIPAA compliance. And then there's just some additional considerations here if you connect to MCP servers, if issues related to prompt injection. And so finally, we come to the end of the report, and essentially what it recommends is that the minimum tier for client confidential work is the Teams account, and the recommended tier is the enterprise account. I tend to agree with that approach. I use the team account even though I don't use all of the seats in the team account. The price point, which is around $125 or $150 a month, I think is very reasonable for all of the product that I get. And I have the assurance of confidentiality when I use it for client information. That said, if you're circumspect about turning off training and maintaining as much control as you can over memory, I think you can safely use some of the lower tier accounts too. And again, the solution here also is that you don't have to input client information. So if you don't want to pay the extra cost for the added confidentiality, you can use the lower tiered services and just anonymize the data that you input in. I hope you find this presentation was useful both on the substance of what you need to do to comply with your ethics obligations and confidentiality when you use an AI platform, and also that you see how powerful skills can be and how you can take knowledge that you have and skillify it so that you can use it productively in your practice.